Hi, class. So we're going to be discussing limits of confidentiality today. And this is very important, is one of the things that we stress with our clients when we meet them for the first time is limits of confidentiality. And what the limits of confidentiality are harm to self, others, elder abuse, child abuse, um, and that's when you say, like, those are the things I have to share with somebody else, unless you're obviously under supervision. So you'll be sharing all of your information with your supervisor, which you should also make sure you tell your clients. The limits of confidentiality, when we talk about harm to self, so someone wants to kill themselves, has a plan, has maybe made an attempt, actively is like, I'm going to go home and kill myself right now. Now, SI, suicidal ideation, I call that SI, that's suicidal SI ideation. That's kind of a phrase that you'll hear a lot when you start practicing, is something that happens for people. They have suicidal ideation. That doesn't mean they have a plan. Okay. So every client that has suicidal ideation doesn't necessarily need to be intervened in the same way as someone with an active plan. And so making sure that you have the proper protocols and procedures for crisis situations, I think, is important. So, suicidal ideation might be something that you just have to monitor, talk about. It's a fleeting thought that a person has. They have no intent in doing it. They don't like the thought. It just happens, versus someone who's like, I have a gun. Today's the day. I'm going to go do it. So you kind of got to not be fearful to talk about some of these things with your clients, because one, it matters. And two, it's one of those things where you need to know properly what's going on so that you can handle the situation appropriately. We don't want to put someone in a situation where confidentiality is breached and that wasn't the proper situation and the proper way of handling it. This can feel very overwhelming to you and very scary. And that is why when you start out and seeing clients and seeing people, you have a supervisor. That is who that person is. That's what they're for, to walk you through these types of situations, for you not to feel alone, etc., etc. Okay. So please be mindful. You want to clarify what's going on. How concrete is this? Now, with virtual therapy, this adds a whole new element, which is great, right? Like, we love the fact we can work from home. We love the fact our clients can see us from home. It's convenient. All these things, they're so fantastic. The problem is we need to make sure we have all the accurate information so we know where the person lives if there is a crisis situation. Because you're going to need to know data, facts, logistics for anyone you would have to report anything to. And so please be mindful of that. You've got to make sure that all the appropriate paperwork is filled out, that you have done your part in making sure you can best report on the safety and behalf of your client, but also for the license that you work under. So for your supervisor who's like, putting their license out there to support you, by all means, all those things are really important and needed for you to do in order for all of this to come together. Okay, so make sure you do your part so you're not caught in a situation where you're like, oh my gosh, they don't have the right address, those kinds of things. Sometimes if you see virtual clients, maybe your supervisor will have you ask each time, like, what address they're at, because sometimes people could, they could be working in different locations, things of that nature, could be in different spots every time that you supervise. See them. And so that might be like a clarifying question. It might be best practice. Every site might be a little different how they want you to handle that, but it's really important that you know where your clients are and that their personal information is correct. Phone number, address, things of that nature. So we have harm to self, harm to others. So that's if somebody wants to harm somebody else. Elder abuse, and that's also for disabled adults. So elder abuse is anyone over the age of, I think, 55 and older. that is being abused, taken advantage of financially, taking advantage of, obviously beaten, sexual abuse, coercion, anything of that nature. Also seen with a disabled adult who maybe is being taken advantage of financially, being, again, beaten, verbally abused, psychologically abused, all the same abuse that can happen to children. Not saying that aging adults aren't capable of standing up for themselves, but sometimes you have situations like dementia. Sometimes you have situations of like they're fearful because they live with a family member and that person is like that's part of their livelihood, or that's who's taking care of them, or that's their loved one. Just not really healthy or great situations that they're stuck in. And it's hard for them to speak up for themselves. So those are kinds of things to be mindful of and to be listening for. Obviously, disabled adults may not be able to make decisions for themselves. And so they have like appointed people, like sometimes through the court system or family members that are responsible for them. And that person then could have authority over them, and it could not be good. I'm not saying every situation is that way, but that is something that you would report. And you would need to tell the proper agency. So you would need to call the Adult Protective Services for any sort of like a disabled adult and or aging adult. Then there's the Department of Child Protective Services. That is who you call for any sort of abuse towards children, which that's physical abuse, sexual abuse, psychological abuse, emotional abuse, any of those kinds of things you report. Now, it can feel very intimidating to make your first report. My experience is the Department of Child Protective Services has been very kind and very understanding. So you fill out the report and then you send the report back into them. They fill it out over the phone with you. And that's again where it's important to know as much information as you can so that they can do their end as far as their due diligence in carrying out the report. And then they make the calls. And that's sometimes the hard part, right? Like, there's so much interpretation that we could go through, right? Like maybe a parent acts out, slaps a child, or maybe a parent acts out and does this or does that to a child. And maybe in our mind, we're like, well, that's really not that bad. Or is that child abuse? Or do I need to report that? That seems so severe. That's why you talk to your supervisors about those things. But at the end of the day, I just remind you, it's not your job to be judge and or jury. You don't have to decide how bad it is. The main thing is that you do your due diligence, and the due diligence is reporting. And then the people at CPS or Department of Child Protective Services, that's where they can come in and decide if it's even worth them moving forward with it. Some reports we make, nothing may come of it. And that's okay. That's on them. That's on the people who have to do the research to look into the situation to decide, is this a child abuse case? Is there enough evidence? Do we even move forward? Do we need to talk to the kid? Like, those are the things that they have to decide. That's their job. It's not our job to do their job. It's our job just to let them know what's up. Okay, so please know your role, know your position. You don't have to try to figure out what's going to happen or anticipate it. Now, I practice out of the mindset that I let my clients know if I file a report, assuming client's going to be safe and things of that nature. You may not do that. It's up to you. The reason I do is a lot of times people tell you things and you're the only person they told. So it doesn't take a rocket scientist to figure out that you were the one that reported. And I try to operate, the best I can, as honest as I can in all circumstances. So again, I'm not saying I'm better than anybody. I'm just saying that's how I operate. So just keep that in mind as you're looking at all this, something to consider is potentially reporting. Okay. Do you have to? No. I'm sorry. Yes, you have to report. Do you have to tell that to your client? Not necessarily. You might have, again, proper protocol and procedures for whatever site you're at. That's on you. But it is good to know that the workers aren't supposed to say who reported. But like I said, sometimes your clients will know because they know you're the only person they've told. Now, if your client is in imminent danger, like, if they go home with this person today, you just have to make sure that they're going to get beat or something. You just have to make sure you stress whatever your fear is to the CPS person so that they can properly see the urgency in the situation. So no one, obviously goes home harmed, and or if harm is coming, that the authorities can intervene. So if, like, say a child reporting on a parent, maybe parent's not there, whatever, I'm going to make sure that I tell the worker that I talk to on the phone, child's very afraid, they live with the parent, blah, 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 whatever it is, I need to make it clear what the child said so that they can handle the situation. Now, I'm not going to go walk out if the parent, let's say, came in later. I wouldn't go walk out and let the parent know, by the way, I filed a CPS report on you because the kid's really afraid, because that could escalate things and make it worse for my kid. And, maybe I'm the only outlet this kid has, and this wouldn't be beneficial for the kid to lose therapy, right? So I may not, I'm not going to put a kid in further harm's way, right? As I'm waiting for the authorities to do their job. So those are all things to consider. It's a lot. It's working with, especially if you want to work with kids, this is something you're going to get familiar with, just because that tends to be who gets reported for most, I would say. Maybe if you work with an aging adult population or a disabled adult population, you'll do some of this as well. But it's important for you to just remember, it's not your job to be worried about what's going to happen to these people. Or a lot of times they just want to give resources to, like, maybe it's a parenting issue. Like, how their kid is, they're difficult, so if you lived with them all the time, you could understand why something happened, not saying abuse is ever okay, but I'm just saying you could understand maybe why parent reacted the type of way, whatever that may be. I accidentally changed the chapter here. But the main thing is that we're doing our job because you have worked too hard to lose your license over a situation because you are afraid. And I'm not talking about for your safety, but just afraid of upsetting someone or their feelings or whatever, because you really don't know what's going to happen. Okay. So I just want to stress that to you. Just want you to be mindful of that. Also, I just want you to remember that reporting is, can be part of our job. For some of you, it may be more frequent depending kind of the setting you work, but it won't be all of your job, hopefully. So don't let any of this discourage you from our field or what you will do. It's going to be part of it, and you need to know it, and it's important because there can be legal ramifications like liability and things. But it's important for us to just know that this is part of what we do, not all that we do. Okay. So privileged communication is a legal concept that comes up a lot of times in regards to sharing information. Generally bars the disclosure of confidential communications made to the psychotherapist from any judicial process. So you can claim privilege on behalf of your clients. All states have enacted into law some form of psychotherapist client privilege. Which means you could claim privilege on behalf of your client, and that doesn't mean you have to hand over their information. And it's trying to maintain that my client has a right to confidentiality. You might ask, what are certain situations? You probably could think of, if you've ever watched Law and Order, there could be Law and Order type situations where someone wants a client file, For our situation, sometimes that could be custody stuff. Sometimes that could be, I don't know. I think a lot comes up with custody type things. Maybe a situation with disability or things of that nature, maybe. But we're trying in all ways to protect our clients, especially if they don't want their information put out there. So therapists can refuse to answer questions in court or refuse to produce a client's records for court. These laws ensure that personal and sensitive client information will be protected from exposure by therapists in legal proceedings. So we do have rights to protect our client. Now, the court can keep going after that if needed, and you may still have to give up your records, but we can try our best to not allow that. Clients can be asked to give summaries, and then the client can ask you to give a summary if you feel comfortable doing so. So it's, again, at your stage, you'll talk to your supervisor about that. You wouldn't have to handle anything like that by yourself. That is why I like the agency Kampft, because Kampft has a lawyer Monday through Friday that we as clinicians, assuming you pay into it, can have access and run some of these questions by, which is really helpful. Yeah, so I appreciate that because I'm not an expert and I don't know every situation. And sometimes when court starts getting tossed around, we can feel intimidated. Some of you might have a legal background, and so you're like, it's no big deal. For me, I don't. And so it can feel like they have the power. And then after I talked to the Kampft attorney, he really helped me empower myself and feel like, actually, no, the ball is in my court. And I've felt these situations a couple times dealing with parents of a minor. I was seeing parents hated each other, of course. And so they're pulling here and they're pulling there. And finally, I got the confidence from the Kampft attorney, partially too, right or wrong. I was kind of over the situation. So I was like, you know what? If they fire me, that's the worst case scenario. Lucky me, you know? But I was able to hold my ground and really hold my ground for my minor, and which really was to either parent, not to either parent's advantage, which I was happy about because they stopped begging me for things. And then I made it clear, if what I do for you, I'm going to do for the other. So this isn't going to set you apart from the other person. So a lot of that I had to fight for, but I felt more confidence in doing so after I spoke to an attorney. So something to think about, you know, Kampft is one of those organizations, California Marriage and Family Therapists. Great thing to, you know, have as a resource, just in case. So anyhow, there's some different cases that are talked about in this chapter. I wanted to get to TerraSoft because that's important. Not that all these aren't important, but now confidentiality in a school setting is kind of interesting. I have a contract with a school district locally, and kids have some rights, obviously, within a school setting. So I think if you can consent for treatment for yourself 12 and older. So a lot of times in high schools, parents may not know that children are seeing a therapist in school. Counselor may not have to get consent. Elementary, elementary, they have to get consent unless they're a certain age. Now, some students will have IEPs, which will allow them to have social emotional minutes, which they will do therapy, whereas the parent is consenting to the IEP, which is the individualized education plan. So they're very aware. But in most circumstances, clients, meaning students, have the right to, if they're 12 and older, to consent to treatment on their own. Okay, so just things to be mindful of. It's still required to be a mandated reporter. Teachers, anyone in education, as far as like school education, is required to. In a church setting, they're mandated reporters as well. Police officers, therapists, I think nurses, doctors, all mandated reporters. So things to be aware of, like you shouldn't be the only one, but once we have the information and we're working as a clinician, we need to then do our due diligence on our end. Okay. But it is interesting in a school setting because not everything a school counselor has to do. They operate under FERPA versus HIPAA, and that has to do with educational rights versus medical rights. And that medical rights, you have the right to privacy and your medical records not just getting flaunted about. And that's the same with your educational records, but on the education side, which is called FERPA. So it's a little different than HIPAA and FERPA are different from each other, but just being mindful, like the HIPAA laws are not the same. If you work in a school setting, then they aren't HIPAA, they're FERPA. So those are things just to be mindful of depending on where you decide to work. So I wanted to get to TerraSoft here because this goes to duty to warn. It's a very sad situation about a therapist who had a client who threatened to harm someone, and ended up harming someone and killing them. Very sad situation. And so as a result of it, we have the Tarasoff laws, which are due to somebody unfortunately getting harmed. So I mentioned Tarasoff. So in 1969, a student health service, a volunteer outpatient at the student health service at the University of Berkeley, was in counseling with the psychologist with the last name Moore. He had confided to his therapist the intention of killing an unnamed woman when she returned from an extended trip in Brazil. In consultation with other university counselors, Moore made the assessment that the client was dangerous and should be committed to a mental hospital for observation. Moore later called the campus police and told them of the death threat and of his conclusion that the client was dangerous. The campus officers did take the client into custody for questioning, but they later released him when he gave evidence of being rational and promised to stay away from Tarasoff, the student, the other person. He was never confined to a treatment facility. Moore followed up his call with a formal letter requesting the assistance of the chief of the campus police. Later, Moore's supervisor asked that the letter be returned, ordered that the letter and Moore's case notes be destroyed, and asked that no further action be taken in the case. Tarasoff and her family were never made aware of the potential threat, so the poor girl and her family never knew. Shortly after Tarasoff's return from Brazil, the client killed her. Her parents filed a suit against the Board of Regents and the employees of the university for having failed to notify the victim of the threat. When a lower court dismissed the suit in 1974, the parents appealed and the California Supreme Court ruled in favor of the parents in 1976. So here we are almost 10 years later, holding that a failure to warn an intended victim was professionally irresponsible. The court ruling requires that therapists breach confidentiality in cases where the general welfare and safety of others is involved. This is the duty to warn. This was a California case, and courts in other states are not bound to decide a similar case in the same way. Under the Tarasoff decision, the therapist must accurately diagnose the client's tendency to behave in dangerous ways towards others. The first duty is judged by the standards of professional negligence. In this case, the therapist did not fail in this duty. He even took the additional step of requesting that the dangerous person be detained by the campus police. However, the court held that merely notifying the police was not sufficient to protect the identifiable victim. In the 1974 ruling, the lower court cited a duty to warn, but this duty was expanded by the 1976 court, which was the Supreme Court, when a therapist determines that his patient's presents a serious danger of violence to another, he incurs an obligation to use reasonable care to protect the intended victim against such danger. This is the duty created by the Supreme Court in the Tarasoff decision. So duty to warn. So now if this person identified who this person was, so it was very specific, like he wanted to hurt someone specifically and he identified who that person was. Now you could have a situation where someone wants to hurt someone and they aren't specific. Okay. So we have to do our due diligence to then try to warn, I guess, the authorities or things. We just have to make sure if we're going to break confidentiality, we are really sure of what we're doing. And that's why, again, you talk to a supervisor, you talk to, someone you can consult with to be like, this, because if I'm willing to breach confidentiality, I better be sure it's worth it, right? But in this situation, the poor person who was, and as a clinician, you're never going to forget that, right? Like, this is your claim to fame, which is like a terrible, like, I wouldn't want that. Nobody would want that. And very stressful and very sad for that poor woman and her family and all the things. So you want to make sure you know what you're doing before you just jump in and do it. Okay. Obviously we need to act quickly and we need to act professionally, but we just want to make sure we're acting appropriately. Okay. So, I don't know why, the Berkeley people decided to want to destroy the notes, and it seems like they were trying to cover themselves, but like acting as if it didn't happen doesn't help with the fact that it did, kind of situation. It's a bit shady, which is probably why it went as far as it did. But that's TerraSoft, and that's the basis of how we do things now. That it's a parameter that has been set in place. So please be mindful of that. Also, when it comes to medical confidentiality and clients with HIV and AIDS, they're entitled to their confidentiality. You don't have to warn anybody about them or anything of that nature. But it's important that people are entitled to their privacy, that they feel comfortable. There's a lot of great different resources out there, but and it's specifically affiliated with the HIV AIDS population, and they don't even say that in their voicemails or anything of that nature, because it's really no one's business, your medical condition or things of that nature, nor is it, if that person is having sex with people, necessarily something where it's like a duty to warn, which is maybe a little hard for some people because it's a medical condition. And that could be one of those, like, when is it a duty to warn, and when is it like, well, it's a mutual thing with that person being their choice. It could be a partner, things of that nature. All these situations that could come up with that could be really hard for us to hear, but it's trying to navigate these things through supervision, because sometimes things can feel very uncomfortable for us, but that doesn't mean it's an opportunity to break confidentiality, right? Because we're entitled to it as a client. And so, and we could get sued for doing that. And we don't want lawsuits. No one wants lawsuits. I don't want lawsuits. And our state is probably one of the most litigious states. So we have to really mark our boxes, check our P's and Q's, dot our I's, cross our T's, all those kinds of things. So it's important. I don't want to say it's everything that we do, but it's some of the foundational parts of what we do, and why you need this class before you even start seeing people, because you don't want to make a wrong choice that could end you in some sort of litigious situation. I hope this information was helpful. I wish you all the best this week.